for the high fives to finish up. Good afternoon. My name is Joe Guerra, and it is my distinct pleasure and privilege to be moderating this afternoon's panel, Lawrence v. Texas, 5 years out. Can the promise of liberty and equality be fulfilled? We have a very distinguished group of panelists with us today and a very timely topic to be discussing. As many of you probably know, we've had two major appellate decisions come down in the last couple of weeks. In fact, one just came down earlier this week. The Lawrence decision was decided 5 years ago this month. Its anniversary is coming up in a couple of weeks. And it's fair to say that it was a stunning victory. In 1986, in Bowers v. Hardwick, the Supreme Court had rejected a challenge to Georgia's sodomy statute in an opinion that was not merely dismissive, but openly disdainful and contemptuous, really, of the very idea that the Constitution protected the rights of adults to engage, of adults of the same sex to engage in private, consensual sexual intimacy. Just 17 years later, the court overruled Bowers, saying that its continuance as precedent demeans the lives of homosexual persons. Justice Kennedy's majority opinion is filled with lofty, and some have said self-consciously, poetic language. In many ways, his opinion is an inspiring antidote to the disdain of the Bowers opinion. At the same time, however, his lofty language left a number of important analytical questions unresolved. Justice Kennedy relied on primarily, really exclusively, although he left the equal protection claim, he said it was tenable, but he relied on the due process clause and the concept of liberty, but nowhere in his opinion does he say whether the liberty interests at stake are fundamental, and nowhere does he explain what standard of scrutiny he's applying to the statute at issue. Justice Scalia rushed in to fill this void in his biting dissent. He argued that the court had applied a mere rational basis standard, and yet at the same time he argued that the decision dismantled all morals legislation and would inexorably mandate constitutional protection of same-sex marriage. And it's quite notable that Justice Kennedy refrains from engaging in any debate with Scalia's dissent. As a result of its ambiguity, the Lawrence decision proved to be a very fertile ground for academic literature. It has spawned hundreds, literally, of articles debating its precise meaning, scope, and significance, and we have some of the participants in that debate with us today. But until quite recently, the federal courts themselves have not weighed in much on this debate. One notable exception, in 2004, the 11th Circuit in the Lofton case read Lawrence as adopting a rational basis standard, and applying that standard concluded that a Florida statute prohibiting same-sex couples from adopting children was constitutional. But largely apart from that decision, there was not much activity until quite recently. And as I said, just in the last 3 weeks, we've now had two appellate decisions coming down on the don't ask, don't tell policy. The Ninth Circuit held in the Witt case that Lawrence did indeed recognize a significant liberty interest that triggered intermediate scrutiny. And in the as-applied challenge, it concluded that further factual development was necessary to determine whether don't ask, don't tell, as applied to Major Witt in that case, was in fact constitutional. The First Circuit in the Cook case also read Lawrence as adopting an intermediate standard, but then essentially concluded that because Congress had thoroughly investigated the question and thought long and hard about its rationale, the don't ask, don't tell policy would survive an as-applied challenge. And of course, outside the federal arena, we have the California marriage case decided in the last few weeks. So we have a terrific panel to help us sort through these new developments and to discuss what Lawrence may mean for future litigation and in the political arena as well. I've been instructed to keep my summary of the many achievements of our panelists to a bare minimum and to direct you to the convention materials for further elaboration in the interest of saving time. And I'm going to introduce our speakers in the order in which they're going to talk. First up is Paul Smith. Paul is a nationally recognized and a highly regarded appellate practitioner at Jenner & Block. who has argued 13 cases at the Supreme Court. And I think it's fair to say that, at least for present purposes, the most notable of those cases is that he represented the petitioner in Lawrence v. Texas. Paul is also the chair of the National Board of Directors of the American Constitution Society. He told me that would be a major faux pas if I didn't mention that. And a member of the Board of Directors of the Lambda Legal Defense and Education Fund. Paul will be followed by Nan Hunter, who is currently a professor of law at Brooklyn Law School, where she has been directing the Center on Health, Science, and Public Policy, but she will soon be joining my old alma mater, Georgetown University Law Center, this fall. She's the co-author, along with Professor William Eskridge, of the casebook Sexuality, Gender, and the Law, and has written several articles on today's topics, one of which was cited in the Cook decision by the First Circuit. But she's not taking responsibility for the result in that case. Next up is Dale Carpenter, who is a professor of law at the University of Minnesota Law School, where he teaches constitutional law, First Amendment law, and sexual orientation in the law. Since 2004, Dale has served as an editor of constitutional commentary, and he's currently at work on a book about Lawrence, which is due to be published in 2009, Dale?
That's the latest date.
With pocket parts to follow. And finally, Dale will be followed by Alexander Robinson, who is the Executive Director and Chief Executive Officer of the National Black Justice Coalition, which is the nation's black, lesbian, gay, bisexual, and transgendered civil rights organization. Alexander has worked as a political consultant for a wide variety of public interest groups, and from 1990 to 96, he served as the senior congressional lobbyist for the ACLU Gay and Lesbian Rights and AIDS Project. The ground rules here are that each panelist is to speak for approximately 7 minutes, and then we're to have a moderated question and answer discussion among the panelists that I'm supposed to facilitate, and then we'll be happy to take questions from the audience. And to the extent that folks do want to pose questions, we ask that you come up and use the microphone up here so that the speakers don't have to repeat every question to the audience. I don't intend to bring down a gavel on 7 minutes, but I rely on the good faith of our panelists. Paul, you're up.
Thanks very much, Joe, and thanks to all of you for being here. It's a topic I like to talk about. But we're going to spend a lot of time, I think, on this panel talking about how Lawrence looks 5 years later and whether it has fulfilled its promise. But I thought I would start off by talking about what was achieved the minute that the case came down, and which the victory, which clearly is still very, very important, regardless of what may or may not have happened since then in terms of extending the victory even further. Why was Lawrence so important? Well, as you all know, I guess it threw out sodomy laws, which still existed in 13 states, which made it a criminal act to basically be gay. And those laws, while they were perhaps not all that often enforced against private consensual adult activity as they were in Lawrence itself, were used as a pretext to justify all sorts of discrimination in those states where they existed, in terms of taking people's children away from them, firing them if they came out from public employment. Enormous numbers of injustices were done because of these laws, and that's why there was a long effort to eliminate them, going back many, many years, both before Bowers and then for a number of years after Bowers, a very carefully orchestrated campaign by Lambda Legal, ACLU, and others to chip away at these laws and finally get to the point where the right perfect opportunity came along with the Lawrence fact setting to eliminate them. The victory, though, wasn't just getting rid of those laws. It was getting rid of Bowers versus Hardwick itself, which, because of what the court had been willing to say, was an enormous barrier to civil rights progress across the entire country. Basically, the argument was made over and over and over again in all kinds of settings that those seeking to establish civil rights for LGBT citizens must be kidding. If the Supreme Court of the United States says there's nothing wrong with criminalizing your private adult consensual activity with your partner in your own private home, what form of discrimination can there be which is unconstitutional? An argument we saw, for example, in Justice Scalia's dissent in the Romer case and in a whole variety of lower court cases over the years. So this was a case where losing in the Supreme Court had made things enormously worse than doing nothing. And so the victory was both eliminating sodomy laws, but also getting the Supreme Court of the United States on record as saying, as Justice Kennedy did so eloquently, LGBT relationships are real. These are families. These people have children, many of them. Their relationships are as meaningful to them as anybody else's relationships, and they have rights and they deserve respect. And I think it's hard, perhaps, for everybody in the room to understand what that meant to people who had lived for a number of years in a regime in the United States where they felt like second-class citizens. But you saw all kinds of people, particularly older LGBT people, coming out that day and celebrating in a way that was really quite remarkable because they suddenly felt like this was their country in full as well, in a way that had never been before. So that, of course, initiated enormous changes in the culture as well as in the law. I mean, it was brought about by changes in the culture over the years, too. I mean, certainly by 2003, when I argued the case, the Supreme Court's view of gay people was very different than it had been back in the 80s. But then the culture continued to change precisely because of what the Supreme Court had done. And certainly I think you can say, we'll talk about this some more, it had an enormous indirect effect on the marriage cases which followed in Massachusetts and thereafter very quickly, even though those were on state law grounds. Now, just looking back at it 5 years ago, what did we all think we had in this case? What did the decision say and how did we view it? Well, it seemed clear to us that we had what we'd asked for, which was a case in which the Supreme Court had said the Griswold line of cases, recognizing a fundamental right, fundamental interest in personal privacy of these kinds of private activities, whether it's birth control, abortion, et cetera, should be extended to consensual sexual activity itself, which was a pretty logical extension. As I said to the Supreme Court in the argument, it doesn't make a lot of sense to say you have a constitutional right to get birth control materials, but not a constitutional right to engage in sexual activity. And so we saw this as very clearly part of that tradition and certainly requiring very heightened scrutiny of any law that would interfere with people's choices about with whom they wanted to engage in intimacy or precisely how they wanted to go about it. And it seemed that was certainly what we asked for, and I think that's what Justice Kennedy thought he was giving us. We did, of course, have no analysis that said that precisely that was what was going on. That was probably in part due to the fact that the state didn't really try to justify the law as serving any significant state interest. They just basically were arguing there's no right here, so why do we have to justify it at all? This hasn't been a right, it's been illegal for all time. So you didn't have that kind of balancing that the court had to go through. And on the other hand, precisely because those things weren't there, Justice Scalia was able, in this remarkably contradictory dissent, to raise doubts about whether we had won very much, whether this was anything other than just a rational basis decision, leaving discrimination against gay people being no differently than any other sort of economic regulation in terms of future levels of scrutiny that it would receive. Even as he said, as Joe said, simultaneously the sky is falling and civil marriage as we know it is going to end tomorrow. He managed to keep both of those ideas in the air at the same time. Now, I guess I was, frankly, somewhat surprised that people took Justice Scalia seriously with that. We certainly did see that in the Florida adoption case, the Lofton case, which is, I think, the thing that has been in some ways, the most discouraging about how the courts have treated Lawrence. We're starting to see progress more recently, and we'll talk about. But the Lofton case, this was a law. Florida is the only state in the United States in which it's illegal, just because you admit that you're gay, that it's illegal for you to adopt a child. Now, the state of Florida, in its wisdom, says a single person can adopt. It's not about having a couple or a married couple or anything like that. A single person can adopt. And a gay person can be a foster parent for years and years and years, but they can't ever transform that foster parent relationship into a formal adoption. There was a law passed at a time when Anita Bryant was campaigning against gay people back in the 70s. The legislative debates are just full of horrible animus and a blatant discriminatory motive. And it doesn't serve any rational purpose. I mean, clearly they're not trying to protect children if they will put thousands and thousands of them in foster homes with gay people. And they had a situation in Florida at the time where there were thousands of people waiting for foster care, waiting for adoptions. I mean, there was sort of a huge crisis in their child care system, but at the same time they were simultaneously maintaining this law and defending it all the way up. And what you had playing out in that case was a very interesting debate over what Lawrence means, in which half the judges in the 11th Circuit en banc said it is rational basis, and half the judges, led by Judge Barquette in a great opinion, said no, of course it's not rational basis. It says gay people are going to have to be respected, and this kind of law is obviously discriminatory and unconstitutional. Unfortunately, it was divided. The court divided evenly, 6-6, and the Supreme Court back in 04-05 denied cert on the case. Which, in retrospect may not be so surprising, because while it seemed like an easy case to those of us who thought we knew what Lawrence meant, it was also a case that the United States Supreme Court thought maybe it's a little too soon for us to let the next shoe drop, because it was a case, after all, involving a few things that Lawrence didn't involve. It involved kids. It involved the establishment of a legal family relationship. It starts to look a lot like you're moving toward marriage very quickly. And so, in some sense, maybe that cert denial was the Supreme Court just saying, let's let these things, as they say, percolate for a while. But it was an unfortunate, sort of discouraging development. And we didn't have a lot of case law until very recently saying Lawrence means something much more than that. And so I think I'll let Nan and others talk about the more recent developments and how things look from their perspective 5 years later. But I would say that these don't ask, don't tell decisions in the Ninth Circuit and the First Circuit, while actually having somewhat different outcomes, but both recognize that Lawrence, as a matter of federal constitutional law, does require very serious scrutiny of laws that discriminate. And so in some sense, I have some optimism that Lawrence is starting to come into its own as a muscular precedent that will really be used to try to make the world a better place.
Thanks. Okay, thank you very much, Paul, and thanks to ACS for inviting me to speak again on Lawrence. Also one of my favorite topics, even if I didn't argue the case the way Paul did. I want to talk about a couple of aspects of what has happened since, and sort of suggest what I see as being some trends that are possibly developing in the law. One of them is definitely optimistic. And one of them is sort of very cautiously optimistic. The first trend, I would say, is that regardless of, think about what the rational basis test does and doesn't do. At its most lenient, it basically gives government a carte blanche to classify and categorize people with virtually any plausible or semi-plausible basis that anyone can think of that either was before the legislature at the time, or that the court can imagine might have been before the legislature. So there's essentially what it does is say to the government, unless there's this very clear showing of animus or something that has obviously contaminated the process, a standard which was met, I think, in Lofton, even though the court found that it wasn't. But barring that, you guys are, we live in a democracy and legislative majorities rule, and you guys are free to do that. One of the things that I think is interesting about what has happened since Lawrence is, even though the majority of courts that have discussed the standard have wrestled with it and found that it's probably a rational basis, we can't really see anything else, a lot of the courts, both in dealing with cases that are clearly sort of Lawrence progeny, and even in the marriage cases, where I think in some ways this is even more interesting, the states are offering, and the courts are sort of implicitly requiring, serious rationales for these classifications. Now, we may not agree with some of the rationale, the sort of reckless heterosexuality, is a real stunner of a rationale for excluding same-sex couples from marriage. But, the advocates are very serious about it. The courts look at it. There are lots of citations to social science material and so on and so forth. So one of the things that I think, to me, that is most interesting about what has happened since Lawrence is what has happened to, morality. I mean, in the immediate aftermath of Lawrence, there was a lot of debate and discussion about, well, does this mean that legislatures can't legislate simply based on morality? Is that what Lawrence has done? You know, and very sort of abstract discussions and examples of other things, and was, you know, were laws against murder, laws based on morality, and so on and so forth. What's interesting to me is that as the cases have played out, for the most part, this is not universal, but for the most part, across a range of areas in LGBT law, the debates have focused on what could plausibly be characterized as real reasons, with at least proffers of an evidentiary basis or some kind of justification other than morality for discrimination against LGBT people, for violations of rights across a range of areas. And I think that kind of slow fade from the debate of the whole morality discourse is one of the most interesting sort of in the penumbra of doctrine, perhaps, developments that's happened since Lawrence. That's the truly optimistic piece. The other piece is in thinking about this, you know, what is the standard of review? Well, the court in Lawrence, I think, wasn't unaware that it was leaving that question substantially unanswered. I think of the silences in that opinion as being probably both strategic, probably the product of interaction among the justices in terms of bringing all the justices that were possible to bring onto that opinion onto it, but also functional, right? As Paul suggested, the idea that this is going to be seen as a big deal. And that we should just let this percolate a while. So what has happened in the doctrine as this sort of percolation process has gone on? It's an interesting problem for the courts, I think, for the Supreme Court and for the judiciary generally, because historically speaking, you've got this minority that is way more legitimate now than it used to be even 10 years ago, say. And yet you've got, on the federal side, in the federal courts especially, not so much in the state courts, I think state courts, I hope, will increasingly follow California's lead in utilizing strict scrutiny for equal protection arguments, but I really don't see that happening in the federal courts. I don't think the Supreme Court really wants to embark on what they fear might be a slippery slope. So how do the courts, how does the judiciary navigate this moment when this serious, increasingly legitimate, politically viable social minority is litigating in the courts? What kind, you know, and that's going to play itself out in the standard of review. So what is the standard of review going to be? Well, the Witt case, which is one of the two Court of Appeals cases that both Joe and Paul referred to, and I think as Joe said, in that case the court read Lawrence to recognize a significant personal liberty, not a fundamental right, not simply some interest of protecting, sort of purely libertarian argument of protecting against government intrusion, but a significant personal liberty, and therefore required the government to justify it under a heightened scrutiny standard. Now, they ended up remanding because they found that on the record before it they could not determine whether all the steps of that standard had been met. But looking at it as a personal relationship, a protected personal relationship in the way that the Ninth Circuit did in Witt, and laying out, based on Sell versus United States, a case that involved forcible administration of psychotropic medication, in which the Supreme Court had used the concept of a significant personal liberty, albeit in a very different context. I mean, I don't know, sex, drugs, rock and roll, but still, that seems like, who knows what was going on there. So significant personal liberty. Well, one of the things that I see happening and kind of how the courts are trying to grapple with this, what must be for them a problem, right? How do you deal with this in the law, and especially in equal protection law? So it seems to me that they're sort of moving in a direction that's starting to look like the proportionality analysis that you see in judicial decisions from other Commonwealth nations, from Canada, from Great Britain, from South Africa, which is a very discretionary standard. It's very much weighing the nature of the individual interest, liberty interest or equality interest, against the nature of the government's interest, and often with the articulation of multiple steps. So my sense that the court, and the court has not articulated it this way, but it's really starting to feel to me like I'm reading some of the decisions from other Commonwealth nations. And that's a very dicey proposition, I have to say, because the nature of that test, the flexibility of that test, it's not a rational basis test. It does put the government to the test. It does force the proffer of something real as a justification. But it's a test, a standard that leaves a great deal of discretion in the hands of the judiciary. And given the state, certainly the federal judiciary at this point, I think this has to give us pause. So I would just throw those out as two topics to discuss about where Lawrence has taken us so far. Thanks.
Thanks, Dan. Dale?
Well, I want to thank the American Constitution Society for inviting me. I think I'm the token Federalist Society affiliate on the panel. One of us is put on these panels every time, I think, primarily to be hissed at and pilloried, so you can start now if you want.
If it makes you feel any better, I've been the ACS person at a Federalist Society. So.
The reverse does work. And I want to thank Joe for not going beyond summaries of our accomplishments, because unlike my distinguished co-panelists, my accomplishments don't go much beyond the summary. So I like the false equivalence. Let me talk about what I think might have been hoped for in the summer of 2003 for those of us like me who supported the result in the case, and talk a bit about what has happened since then and see if those hopes have been fulfilled in any way. So I think in the summer of 2003, there might have been a lot of hope that Lawrence would prove to be a fertile basis for many advances in the rights of gays and lesbians in the country. It had done at least, I think the court had done at least 4 very important things that seemed clear at the time. First of all, it had revived the doctrine of substantive due process. And many people forget that that doctrine had started to seem dead. It had been covered over in musty traditions that were not very sympathetic to gay equality claims in cases like Bowers, of course, and in Washington versus Glucksberg. Notably, the court doesn't even mention Washington versus Glucksberg in its decision in Lawrence. Second, the court had defined the right that was being protected in Lawrence quite broadly as a right to something like adult sexual autonomy or intimacy, not as a right to homosexual sodomy, which is the way that the court had defined it 17 years before in Bowers versus Hardwick. That was potentially significant. Third, the court talked about respecting relationships and not just about protecting, not just about sex. So where the Supreme Court in Bowers versus Hardwick had talked about gays as having sex, Lawrence had talked about gays as having relationships, of which sex was a part, an important part, but just a part. That suggested, although the court distanced itself from the conclusion, but it suggested that maybe the decision would have application beyond physical acts. And then fourth, as Paul mentioned, the court had overruled Bowers versus Hardwick, which did enormous damage in many, many contexts to gay rights claims, and frankly had done damage politically to gays as well, because Bowers and the presumptive criminal status of gay people was not just being used in courts, it was being used in legislatures to make positive political change. Despite what looked like those significant accomplishments, however, there was a problem with this opinion from the outset, and it's already been alluded to a bit. The opinion was incredibly opaque. There was a lot of talk in Justice Kennedy's opinion about transcendent dimensions and the autonomy of self and so on, and a lot of the opinion was devoted to unpacking the history of sodomy laws, to complexifying the court's earlier discussion of this issue in Bowers versus Hardwick. And that was important, but it wasn't nearly enough, because what was missing, the pages that were missing from this decision were the conventional constitutional analysis. Things like what sort of right are we dealing with here? What sort of scrutiny is going to apply to any infringement on this right? There's nothing explicit about any of that in this opinion. There's a lot of speculation about why the opinion is so opaque. I don't have any better guess than most other people have. I suspect there just weren't 5 votes for a clearer opinion, and Justice Kennedy may have wanted to keep his options open for the future. By the way, there's a pattern here. Remember, Justice Kennedy wrote the similarly opaque and unconventional opinion in Romer versus Evans 7 years before Lawrence versus Texas. So anyway, into that vacuum, that interpretive vacuum, there were 3 basic strands of interpretation of the decision that came out. There are many possible interpretations, but 3 main ones. One was that Lawrence versus Texas was a fundamental rights case. This is certainly the view that Paul took of the decision. It's the view I took of the decision. People like Lawrence Tribe and Michael Dorff and Eugene Volokh and lots of others thought that this was a fundamental rights case. And if it was a fundamental rights case, then it was a very, very significant case because it suggested that a lot of anti-gay discrimination could be attacked as a kind of impermissible burden on the exercise of the right. That was one view. The second possible view was the view that people like Nan Hunter took, which was that Lawrence really represented a rejection of the old standard bifurcated model of substantive due process rights, where we have fundamental rights on the one hand and we have liberty interests on the other. And the court was just doing something new. And what new thing it was doing wasn't entirely clear. Nan suggested in an article that the court may have been starting down a path of balancing governmental interests against liberty interests. Randy Barnett suggested, for example, that the new path might be a libertarian presumption, which would open up all kinds of possible rights claims, including economic liberties. That was a second possible view. Third possible view was that Lawrence versus Texas was a rational basis case, that the court had not declared a fundamental right, and that whatever interest was being exercised in the bedroom that night was a mere liberty interest. And the only real impact of the decision, according to Justice Scalia, who championed this interpretation of the decision, was that unadorned moral justifications for laws would not be enough. And while Scalia certainly thought that was a big deal, it really wasn't. One of my old law professors, Richard Epstein at Chicago, once described the rational basis test as basically saying that a law is constitutional as long as any fool can come up with a stupid reason for a bad law. It's not ordinarily terribly demanding, and if the rational basis is really what applies, if it's the old-fashioned rational basis at least, then almost every law is going to be constitutional beyond sodomy laws. So that was 2003, and those seemed like the major possibilities. What's happened since then? Well, 5 years later, while the Supreme Court could still weigh in and clear up some of the confusion and the disagreement, I think that at least in the lower courts so far, both in the federal and state courts, if you just tally up the opinions, Justice Scalia's view of Lawrence versus Texas has largely prevailed. And in fact, until the last couple of months, I would have said it wasn't even a close contest, although a couple of opinions have made it kind of interesting since then. This is one of those occasions when a dissenting opinion from the Supreme Court actually is turning out so far to be the controlling opinion from the Supreme Court. It is the one that is dominating interpretation of the opinion. And in fact, if you look at a lot of these decisions, the courts often cite Justice Scalia's dissent as the authoritative view of what this opinion means. Now, you can see that in a lot of cases. I'll only mention a couple of them. The Lofton case has already been mentioned. It's the most prominent example, I think the most notorious as well. And the 11th Circuit said in that case that Florida's adoption law was perfectly fine because Lawrence is nothing more than a rational basis case, and that if this represents some sort of infringement on a right recognized in Lawrence, then the state of Florida needs only have a rational justification for what it has done. And the 11th Circuit thought that was the case because a fool could come up with a stupid reason for that bad law. The 10th Circuit recently, in a case involving a city's reprimand of a police officer for having an adulterous affair, this one came down earlier this week, the 10th Circuit similarly read Lawrence as essentially a rational basis case and said that the reprimand of the police officer was perfectly fine. There's also dicta in Fifth Circuit opinions and in I think at least one Seventh Circuit opinion so far suggesting that Lawrence is a rational basis case. And then you can look at lots of district court opinions and state court opinions, especially dealing with the marriage issue, in which courts have said Lawrence was a rational basis case. Now, we have had, in the last couple of months, a couple of interesting decisions. One of them is this Witt case, the Ninth Circuit case, which sent back for further factual review the challenge to the don't ask, don't tell policy in the Ninth Circuit, and did so instructing the district court to apply something that looks like intermediate scrutiny. That's an interesting result, although one always wonders, I mean, this is a Ninth Circuit case, so one always wonders how far that's going to go. The First Circuit held very recently that Lawrence requires a balancing of the government's interest in regulation against the individual's liberty interest, and cited Nan Hunter as the authoritative source for that view of Lawrence versus Texas. I think she should be very happy about that, except that the result was balancing those interests. The court said, well, you've got Congress on the one hand supposedly doing a very careful, factual look at the needs of military and so on, and finding that it's perfectly justified to have this policy. And the interest recognized in Lawrence, said the First Circuit, was a narrow liberty interest, characterized it as a narrow liberty interest. I don't know how you read the Lawrence opinion and come to that conclusion, but the First Circuit apparently did. So I don't have a lot of hope for that kind of balancing. It may be that you could balance the interests in a different way, but so far it doesn't look very comforting. We even, believe it or not, have a circuit split on sex toys after Lawrence versus Texas, with the 11th Circuit, of course, saying that the ban on sex toys is constitutional, and the Fifth Circuit saying after Lawrence versus Texas that it's not. Then we've had lots of developments on the marriage issue. The one thing that Justice Scalia had warned in Lawrence versus Texas we would get because of that decision, because it had dismantled the structure of Constitution. Remember that line? It dismantled the structure of constitutional law that allowed the state to limit marriage to opposite-sex couples. The one thing that he said we would get because of Lawrence, we haven't gotten. Now, we do have a couple of opinions from state high courts. The Massachusetts court back in 2003, a few months after Lawrence, and then, of course, recently the California Supreme Court, that cite Lawrence and that quote flowery things from it. But they don't rely on Lawrence for any great substantive force that those courts wouldn't have gotten from their own opinions. And I don't think they reached the result that they reached because Lawrence was decided. I think they would have probably reached the result even in the absence of the Supreme Court having decided that case. So I don't think it's fair to say the court's opinion is being read, as Justice Scalia thought, to lead ineluctably to gay marriage around the country. If it's going to be read that way, it's probably a few years off. So we've gotten, from a gay rights perspective, all the worst from Justice Scalia's interpretation of the opinion, and none of the best of Justice Scalia's interpretation of the opinion. Now, there are cases, these pending don't ask, don't tell cases may help us clarify things. The Supreme Court may have an opportunity somewhere in the next few years to tell us what it meant, but so far that hasn't happened, and it may not happen anytime soon. Given the composition of the federal courts right now, it shouldn't be surprising that given a choice between a plausibly broad reading of Lawrence versus Texas and a plausibly narrow reading of Lawrence versus Texas, the courts have chosen the narrow reading. If they were going to, if this decision was going to be used as a way to advance gay equality claims in the federal courts, those lower courts needed clear marching orders from the Supreme Court. And instead what they got was poetry. Now, I'm not saying that it's necessarily bad that Lawrence isn't being read very broadly and aggressively. I think the future of gay rights is probably on everything from marriage to ending the military ban going to depend on making progress with the public and in legislatures, and I think we may be on the verge of doing that in lots of places around the country.
Thanks, Dale. I'm going to ask everybody to hold their hisses until Alexander's had a chance to talk.
Good afternoon, everyone. It's a pleasure to be here. With so much agreement on the courts and even on this panel of what Lawrence actually meant and said, you can imagine that politicians, of course, jumped at the opportunity to make a difference in the lives of lesbian and gay people after Lawrence. I want to talk sort of less about the law here. We've got some individuals on this panel who do a lot better job than me of that, and talk about the political implications and what we've seen. Certainly, like many cases that talk about liberty rights, Lawrence both sort of led and followed where public opinion and the political environment was at the time. Followed in that there was pretty much broad acceptance of the notion that the government should stay out of the private consensual behavior of adults, although we still have sort of the politics of that and individuals who personally want to inject themselves. But I think that in general that was a broadly held view. And in fact, in some places, even though sodomy laws were still in the books, they were rarely enforced. And when enforced, were enforced more as a tool for harassment rather than a law enforcement, a real law enforcement tool. So I believe that Lawrence followed just where we had moved as in our politics and in sort of public opinion. I think Lawrence led in its rejection of sort of the conduct versus status dimension of politics. The nature, O'Connor and Kennedy's embrace of the core concept of human identity is something that I think we still debate. Certainly, if I look at the data, information polling where you see African Americans in particular on when it comes down to support or failing to support any discrimination in marriage for same-sex couples, the notion of whether of identity and whether or not we're talking about identity or behavior is one that plays a large role in determining whether or not there is support. So I think we're still having this debate over whether or not the objections are around identity or the objections are based on behavior. There are a lot of individuals who've talked about Lawrence, who've talked about its cultural and social significance and compared it to Roe v. Wade, Loving versus Virginia, Brown versus the Board of Education, all of which, in addition to the important and significant legal precedent that was set and legal that was found, had very significant political implications, and that we're seeing progress in those arenas. Still, we're still debating Roe, and we're still fighting to hold on to the promise, both in legal terms, but certainly in practical terms, in the availability and women's ability to access the services in an efficient and effective way. We're still having that debate, though these many years later. If we look at the court led certainly in ending the anti-miscegenation laws. Public opinion was not there. The public was greatly opposed to interracial marriages for many, many years after Loving was decided. Though we have integrated workplaces, public spaces, educational opportunities, we are still one of the most segregated societies that we've ever been. We still live in segregated communities often. If you look at the way in which we have socialized, that remains true. I think one of the interesting political developments, and part of what we're seeing in this current election cycle, is that sort of for the first time, one of the things I talk about with my colleagues and friends, African Americans are on display. Our culture, our habits, things that individuals and people have not seen before. Our churches, even the way in which we greet one another has suddenly burst onto the scene, and I think that this speaks to the level of segregation, that even though we are, again, integrated in our workplaces, we have many diverse workplaces, that in many ways we remain a segregated society. And certainly if we look at public education, that despite the fact that that Brown, the findings of Brown, if we look at the disparities that exist, many of them characterized as being urban, suburban, urban, rural, that the result is often race-based, that you have inner-city schools that are predominantly African-American or Latino, that have fewer resources, and that our educational system undoubtedly serves our children differently. And though those differences are not in theory based on race, we still have those sort of racial divides. So the political and social implications of Lawrence, I think, as we continue, will be interesting to view and watch and see, because certainly we cannot discount the notion of not being illegal anymore, that your very being who you are, that one of the ways in which your identity is formed is lawless, and it is something for which you can be prosecuted. That eliminating that opens up a great deal of opportunities, both for allies to be supportive, because they're no longer sort of going against the tide and trying to put in place protections for individuals who are otherwise deemed as breaking the law, but also for the movement of LGBT folks who are fighting for their rights, and removing this particular very large impediment makes a tremendous difference. That said, when I joined in the fight for lesbian and gay rights and individuals, we were very much a part of a larger sexual liberation movement. And I would say that part of what has transpired, not simply because of Lawrence, but interestingly enough, I think has accelerated after Lawrence, is a real separation of the liberation, sexual liberation, the notion of all private consensual behavior being private and consensual and having no governmental influence, including the use of sex toys. And the notion that gay and lesbian couples and in their relationships being protected and being protected in the workplace. Certainly, if we look at the way in which the sodomy laws have been used, often to target gay men, sex in public places, used as a tool of harassment. Eliminating sodomy laws has not eliminated that form of harassment. We need to look no further than Senator Larry Craig to know that there is still this notion, whatever you might think about him or his behavior, the behavior of the police is just as reprehensible. The notion that public resources are being used for someone to target individuals in the surreptitious manner that happened suggests that the mere absence of illegality of sodomy has not removed the government's interest and willingness to target certain parts of society. Marriage is probably one of the most conservative institutions that we have, and we as LGBT individuals are anxious to join in that institution. And while I'm not here to critique that, I would just point it out as an interesting development for a movement that was at one time really on the leading, cutting edge of sort of leading the sexual liberation movement, eliminating sort of the heterosexist model that has both influenced negatively, I think, our laws and our overall society. I think if we look at the political progress that we've made, though, certainly the number of states, localities that have expanded their laws to include workplace protections, to include anti-harassment laws in our schools, the fact that we are now in rigorous debates in many places across the country and not only protecting individuals based on sexual orientation, but also on gender identity and gender expression, I think is certainly indicative of the opening up of the way of our line of thinking and the opportunities that are available for protecting individuals who do not conform to particular gender roles, or who are gay or lesbian individuals. I think that one of my expectations, and something that is disappointing, and there are a lot of sort of political reasons for that, but I had hoped that Don't Ask, Don't Tell certainly would have seen its last days sooner than it has. It seems to me that we have certainly made the case for federal protections in the workplace. And it also seems to me that at this point in our history, given the cultural changes that have been made, and as was pointed out, I think, in preparing for this particular panel, I went back and I actually read Lawrence. And what's interesting about it is that if sort of we have had politically embraced a lot of the language that was there, we would be in a very different place, I think. That we would have not just be talking about whether or not we could pass a federal bill that protected us in the workplace, but in public accommodations and sort of the broad range of activities in which we're engaged, which is part of where, when I was at the ACLU, where we started this debate. So I think that certainly there are political opportunities that have opened up, and I can't hardly discount the notion of, again, removing that huge both psychological but legal impediment that sodomy laws impose On the other hand, I think that there are also lots of questions, challenges that still remain if we are to change the political environment so that people, regardless of their sexual orientation, are able to live openly and honestly and have all the protections that all of us need in order to create that more perfect union.
Thank you. By my rough calculation, I think we're averaging 11 minutes presentation, so we're a little over. So I would like to ask in the question and answer period to be, if folks could keep their answers a little more brief. I have a couple of questions I want to raise myself before I turn it over to the audience. I think I'd like to ask Paul, because I saw him scribbling furiously at one point while Dale was talking, if he shares the view that the Scalia dissent has been controlling, or whether the tide is turning at all in light of the two recent decisions. And I would just say that having read them both, I think that they're, notwithstanding ones from the Ninth Circuit, there's some impressive analysis in the cases, but not to prejudge the question too much.
I think what you've seen with Lawrence is a situation which has come along in prior civil rights movements as well, when the courts start to grant rights, of concern about not getting too far ahead of the culture. And so in many ways you can view the opaque quality that Lawrence has as a nice device that has allowed the federal courts to kind of take their time on some of these issues. And, you know, they have a stronger reason to do that, because when you interpret the federal Constitution as giving somebody a right, of course, it applies everywhere. And so you have to take into account a wide variety of cultural conditions in which gay people live around the country. And so I think there has been a kind of temporizing on the part of the federal courts, saying we're not going to take the logical implications of Lawrence and push it as far as fast as we can. And certainly the advocates have not exactly been asking them to do that either. But what you're starting to see, I think, now with these two recent decisions is an acceleration of the movement toward starting to use the federal Constitution again to broaden gay rights. It's not just that there are two circuits that said that there's intermediate scrutiny required. Intermediate scrutiny pretty much parallel to the scrutiny that applies to women, gender claims. But also a dissent by one judge in the Ninth Circuit saying strict scrutiny should apply, Judge Canby. And there's an interesting feature very quickly about the Ninth Circuit decision. It said that the don't ask, don't tell policy has to be justified by the government on remand as applied to this particular major in the Air Force, which means that the government has to somehow prove that in this Air Force base in Washington State, there's a unit cohesion reason why this particular woman has to be thrown out of the Air Force because she had a civilian partner off the base. And the nice thing about that device, if it plays out the way I hope it will, is it essentially starts to chip away at don't ask, don't tell. Instead of asking the federal courts to say it's unconstitutional as a whole and start basically saying that the policy has to be thrown out, using the as-applied device, which is usually a device that's used to sort of defeat people's constitutional claims as a way to sort of encourage the evolution of constitutional claims, but gradually as the culture kind of gets more ready for it. And so I'm optimistic about the future. Of course, much depends on who the fifth vote is in the Supreme Court in a year or two, but we'll have to wait and see how that turns out.
Dale, do you want to comment at all?
I think that might be right.
He's not so bad for a federalist.
I haven't finished my answer yet.
Paul is being optimistic.
The Ninth Circuit opinion is a little odd. It's not even intermediate scrutiny in the way that it was phrased in cases like the VMI case. It's very much its own analysis. I haven't seen anything quite like the Ninth Circuit opinion, so I just don't know how much influence it's going to have, or even if, as applied, it's held that the don't ask, don't tell policy is unconstitutional, it will stand up. But it'll give the Supreme Court, a chance to look at the issue, which might be helpful.
Well, I mean,
the Tenth Circuit, I'm sorry, let me say one thing about the First Circuit opinion. I have to say I don't think of as an intermediate scrutiny decision at all. It's a balancing decision. Now, it's true, it's more than rational basis, but it isn't the kind of skepticism you get in intermediate scrutiny cases where the court is willing to look behind the stated motives of the government. It's just, how strong is the government's interest? We're dealing here with the military. We defer to the government's judgment about military needs. How strong is the individual interest? Well, it's a narrow liberty interest, so it doesn't count for much. I have the impression, Paul, that the reluctance of the lower courts to read Lawrence more broadly so far is much more a consequence of the composition of those courts. And that's something that's going to change, if it's going to change, slowly.
Yeah, the thing that I was going to add, I think the thing that's, one of the things that's so interesting about the Ninth Circuit, and I really agree with Paul's point about its use of as applied, but the other thing, it's an intermediate scrutiny test, which we think of as coming from equal protection law. We associate it with classifications based on sex, for example. But it's utilized in the context of a due process analysis. It's a heightened scrutiny, intermediate scrutiny approach to due process analysis. And in fact, the Ninth Circuit also said that they felt it was clear that in the equal protection context, rational basis was the prevailing standard, but that the liberty interest at issue was a significant liberty interest. And so the case to which the court referred, the Sell case, also a due process case. So it's a very interesting migration there, I think, of an intermediate scrutiny standard to apply to the due process holding of Lawrence. So I don't know whether other courts will take that up or not, but it's a pretty creative way to analyze it, I think.
Well, following up on that, I wanted to ask you, you indicated during your comments that you found the proportionality standard from foreign courts, which I think is very analogous to what we just described as intermediate scrutiny from this merging of equal protection and due process analysis, as somewhat alarming. I would think it's certainly better than rational basis. And in the First Circuit, the First Circuit was made a big deal of the deference that's ordinarily owed the political branches when it comes to military judgments. So I'm wondering, A, if you think outside the military context this standard is as problematic as you hinted at, and what it might portend in more traditional sort of in the adoption context and other circumstances outside of the military.
Well, perhaps I sounded less. Perhaps I emphasized the cautious part of the optimistic too much. I mean, the proportionality test has been very effective in protecting individual liberty and protecting equality interest in other nations. It's just that it's a very sort of discretionary test. It is it's less discretionary than a rational basis. I mean, that's the good part. It forces government to justify. It forces the meeting of certain criteria. But and this is a very sort of suggestive thing. I really would be interested in people's reaction because I haven't fully thought this out. I mean, I read some of the decisions from other Commonwealth courts, and with all due respect and admiration, they can be extremely verbose. The proportionality test does tend to go on and on and on, and I read them sometimes, and I think, would an American court come out that way? Would an American judge come out that way? That's the basis for my caution. The basis for my caution is I think we've all alluded, is the current composition of the federal courts. As a doctrinal, sort of in the abstract, as a doctrinal development, I think it could be very interesting and very productive and very useful to courts who, in facing other social minorities that move from being sort of largely, treated as extremely marginal, if not as almost as kind of social punchlines, to being much more respectable, legitimate social minorities. Again, still minorities, and again, there's plenty of anti-gay humor, or sort of pick your category of humor, but it's definitely a progress. There's definitely movement there, and judges are not immune to detecting that, I think, and to wondering how they're going to adjust the tone and the way that they analyze social interest in the context of a moving target. So right now, the major moving target, it seems, perhaps in the United States, or one of them anyway, in terms of social minorities, is the LGBT community. But that won't always be the same. And I think in, kind of in the back of the court's collective mind is of the Supreme Court and of the federal courts is a sense of not wanting to have to make this strict scrutiny declaration. I think they're increasingly uncomfortable with it, and so I think they want to find a way that allows some give in the joints and allows the judiciary to sort of analyze different social context as the social context in fact changes. So that's what I think the proportionality test brings. And I think the worry is who's doing the judging.
Justice O'Connor has retired, but her philosophy lives on. The incrementalist approach. Does anybody else want to follow it down?
I would say there's some reason to think that such an intermediate scrutiny position can lead to a lot of good things. You certainly don't think that gender discrimination in this country is something that people can put in law without a lot of heavy scrutiny now, given a similar standard. And in that context, we have the example of Rosker versus Goldberg, which is a case where the Supreme Court allowed gender discrimination in draft registration way back in 1981, and basically wrote that same level, all that same language about deference to the military. And so the standard does allow a level of kind of allowing play in the joints that is not there with respect to strict scrutiny and, for example, race classifications. On the other hand, the Supreme Court has largely gone to the point of eradicating gender discrimination in the law in most other areas using just this kind of standards.
That's true, although the fundamental case law in sex discrimination came from a very different era, and in a different composition of the courts.
Well, we may be entering another era. You don't know.
I hope so.
Dale, you look like you're about to say something now.
Well, no, I was only going to add it. In some ways, it may be that because of the traditional deference given to congressional judgments about the military, that the worst context in which to raise the question of the expansiveness of Lawrence may be don't ask, don't tell. There may be other contexts. I think your question suggested this, in which we may have more fruitful avenues. The other thing I was going to say is that I'm a pretty strong believer that the courts very rarely get ahead of the politics, and this is sort of a point I think that Paul made. The California Supreme Court, for example, announced last month in its marriage decision that discrimination based on sexual orientation should be subjected to heightened scrutiny. Well, the California Supreme Court's very brave to say that, but did so only after gay people in the state eliminated just about every form of discrimination from that state's code. So I think it's probably the case that that the progress of Lawrence, in a sense, is going to depend on our progress in making further political gains around the country.
Well, I think that leads to a question, Alexander, about, and everybody really, but to kick it off, the issue of backlash and the question of strategically, what should the targets of litigation be to try to bring the courts along to where they're willing to go without risking either at the kind of horrific language you get in a Bowers decision or a sort of legislative political backlash.
Interesting question. I'm not sure that I would immediately come to mind what the target should be. I would say that I think that we have seen not a little backlash, considering the sort of extraordinary leap forward in some ways that I believe Lawrence was. That, you know, we still have, as we like to euphemistically call it, the ick factor of being gay and lesbian, and that still exists as a social norm, even among individuals who would say we should not be discriminated against. That still exists, and so I think that in the thinking about the sort of the court's following, if you will, and being very conscious of, and as Nan suggested, not immune to the changes that are happening in society. Where we look are those places where the society has become most comfortable with. And this is where I think that, again, the identity versus behavior question becomes one of the most critical. When we actually have to think about sex, it becomes the most, and sexual acts, it becomes the most challenging, I believe. And the one place where that's clearly seems to be an obvious exception is in the military. But I do believe that there are opportunities that are being led by social changes that we see and social acceptance.
Well, you talked a little bit, you and I, offline about the sort of expected backlash versus the reality of it.
Right.
Lawrence.
In terms of Lawrence itself, there was very little backlash. Certainly, there was no outpouring of demonstrations. I never got a nasty letter from anybody or an email or anything. But certainly the marriage cases have produced a fair amount of backlash, and certainly a lot of the amendments. And I think there's every reason to think that if the federal courts were to impose marriage nationally today, there'd be quite a bit of backlash. On the other hand, I think there are things that can be done gradually. I think the popular support is for repealing Don't Ask, Don't Tell. We may well see that legislatively if things go well. And it's not inconceivable that the courts will do that in the next few years as well. There's also things out there like the particular aspect of DOMA that in which the federal government decides that even though you're married in Massachusetts and maybe in California in a week, we're still going to pretend you're not married. I think that is personally, I think that's a very compelling argument to challenge that under the federal Constitution, because the federal government doesn't have any interest that I can think of in dictating to the states when they'll accept their marriages and when they won't. And it has all sorts of very practical consequences to people who lose their pensions and their Social Security benefits, and their taxes go up and that sort of thing. Again, something that may well be fixed legislatively, but is also, I think, something that could be fruitfully constitutionally challenged, perhaps, depending on where the court goes.
I was going to ask one other question before I turn it over to the audience. I think we're getting close to the audience participation portion of our program. But and I know this came up a lot at a prior panel that about half of you actually participated in, and maybe the new decisions have blunted this question. But the question is whether you'd be better off in a world in which Lawrence had gone off more on equal protection grounds, or, as Nan suggested, have you gotten sort of the best of both worlds, or maybe half a loaf from each world in terms of the standard that the courts seem to be developing? And I don't know who wants to tackle that idea first. I think, Dale, you talked a little bit about this in the Atlanta conference, I believe.
Yeah, I actually filed an amicus brief in which we argued that the case should be decided on equal protection grounds rather than on due process grounds. I think it makes more sense doctrinally. I think it would have been a more cautious move by the court, because it would have struck down only 4 of the statutes rather than all 13. And then I think the other 9, eventually you could have gotten to. But what's more important is that ultimately, at least doctrinally, it could have led to heightened scrutiny more directly than a due process decision could do. Now, I think you have to put a large asterisk by that. And the asterisk would be even an equal protection decision would have been subject to interpretation and application in lower federal courts that are, by and large, profoundly hostile to the idea that the federal court should be used to advance gay rights claims. So, having made the argument 5 years ago that this should be decided on equal protection grounds, I'm not sure it would have made a huge difference, at least if the equal protection decision would have been kind of equal protection poetry rather than equal protection marching orders. So I don't know that it would have made a big difference.
It probably would have been harder to avoid the level of scrutiny issue. I mean, it's almost impossible to write an equal protection decision. Although Romer comes
It might be hard to write the second equal protection issue.
One of my colleagues, and of course I do not share this view. One of my colleagues always says at the law school that the 8 most frightening words in constitutional law are Justice Kennedy delivered the opinion.
a view I do not share.
I don't share this view, but some people out there do, and so if he'd written it, he could. If anybody could have avoided conventional constitutional analysis in an equal protection case, I think he could have.
But leaving Bowers unoverruled and leaving some of the sodomy laws out there in place just because they didn't expressly discriminate against gay people would have created a real morass.
Yeah.
I mean, Justice O'Connor, who suggested we should go on equal protection in her current, said, well, maybe they would be unconstitutional as applied because they're only enforced against gay people, which is true. I mean, when was the last time you heard of a sodomy law being enforced against a married couple? It just doesn't happen. But they would have been, there's an awful lot of legal problems with trying to go after those laws under an equal protection analysis. And so.
But you did push both.
We did. In fact, I expected them to go off on equal protection, likely because the law was so grotesquely discriminatory. The Texas homosexual conduct law, which is the exact same conduct as legal if it's the opposite sex couple, but not the same sex couple. And it was passed in 1972 when they repealed all regulation of sexuality, including like bestiality laws were repealed and everything.
Adultery laws were repealed then.
Right. Yeah. All the fornication laws, they were all repealed, but they passed this new law just for this. So it was kind of a nice equal protection argument. In some ways, I think Justice Kennedy had a lot of wisdom in deciding to go the direction they did, and certainly Justice Ginsburg very much wanted to overrule Bowers. I remember her asking me in the argument, "You are asking us to overrule Bowers, aren't you?" Not the most difficult question I had that day.
Does anybody want to venture up to the microphone and ask a question?
Hi. I have a comment and a question. My name is Kathleen Morris. I'm a deputy city attorney for San Francisco, and I was one of the counsel in the marriage case. My comment is that it's very easy. I mean, we've heard sort of like shots taken at the Ninth Circuit where I clerked, shots taken at the California Supreme Court where I live, and I thought, I should stand up as the city and county in San Francisco to give you like a juicier target. So that's one reason why I stood up. Another reason why I stood up is because I think that the reason that I am more hopeful about the California decision than maybe some of these panelists, especially Dale, is because if you look at the fact that 6 of the 7 justices are Republican, that number one. Number two, all 6 of them, I think, and certainly the chief, who is the author of the opinion, is a judicial incrementalist. And I somewhat expected them to go with the California privacy provision, and instead they cleared the table. And number 3, while it's true that California does have a lot of anti-discrimination law in the books, it's also true in terms of political courage that the Knight Initiative was passed not all that long ago. And so that was, in a sense, and that's the popular initiative that was elected by ballot initiative rather than through the legislature. So, there's legislative support for it, but that doesn't necessarily translate to popular support. But now I'm going to argue against that by saying, that we actually were able to get all of the major cities in California to join in a city's amicus brief. So we didn't just get, we got San Diego, Los Angeles, San Jose, Oakland, Sacramento. All of those cities, either through their city attorney or more often through their a combination of their board of supervisors or their city council people and their mayor, voted to say, we stand shoulder to shoulder with San Francisco in their interpretation of what the California Constitution requires, and a lot of those cities are profoundly Republican places. They're places with military histories. They're places with current military bases, et cetera, et cetera. The question that I have, though, is this, which is sort of a reverse backlash question. Do you think that an argument could be made that when you talk about the poetry of Justice Kennedy's decision, that it's not marching orders, it's poetry, but do you think that he intends to speak to the electorate? Do you think do you think that his intention is to have, because he speaks in very sort of common sense language. It's not sort of perfect technical legal language, but it's language that ordinary people can understand, and that's something that I feel like is rarely talked about when people make fun of Justice Kennedy. He tries to talk about things in a way that ordinary people can understand, and principles in a way that ordinary people can understand. And do you think, I guess I'm asking the panel and especially Dale, do you think that politically we'd be in a better position today if Lawrence had been decided the other way?
You mean more specifically, not
well,
the other
yeah.
outcome?
What I mean is that really is that really you guys have been focusing on the aftermath of Lawrence, in the sense of like when cases were brought in courts after Lawrence, what happened and how was Lawrence specifically applied, as opposed to what effects did Lawrence have more broadly outside the courts, if any. Maybe we don't know the answer to it, but I was just curious about whether you had an opinion about that.
Yeah, boy, you and I read Justice Kennedy differently. I don't think he writes in common sense ways, but then you have to take that with a large grain of salt because I've been a law professor for 8 years, and I've lost sight of probably what that means. But I don't find his language terribly straightforward, and I doubt that it speaks to the electorate in any way. I don't see people, when I talk about gay rights issues, and I debate this subject a lot, gay marriage and so on a lot, I don't see people bringing out Justice Kennedy quotes in these debates or talking about it. I do think the opinion was important, and it accomplished very, very important things. Regardless, even if it's read only to get rid of sodomy laws, it was a momentous, important, valuable decision. I don't think anything can take that away from it. On California, by the way, you must know Terry Stewart. She was fantastic in the oral argument in the California case. I thought is one of the best presentations I've seen by a lawyer in a California marriage decision. So you had quite an advocate in her. I have to say, though, I think that the lasting legacy of that California marriage decision has not yet been written, and that it may well be written in November. And while attorneys in some of these major cities may have signed on to the briefs, and I think that's terrific, the voters are going to have a say on this, and the result could be a huge setback for marriage in the state of California.
It could be. On the other hand, this is the enormous potential downside. On the other hand, it's one of the greatest opportunities you could possibly imagine to have the voters of the state of California, if they do this, democratically uphold that decision, will put the marriage issue so far ahead of where it was before that happened. It'll be remarkable. So, I mean, on the other hand, if it goes the other way, it's going to be very difficult to overcome it, and we're going to have a lot of civil union laws in this country and not a lot of marriage laws. So, I mean, it seems to me this has become almost the battle of the marriage fight. And it's very close, and it's going to be very interesting to see how it goes.
Yeah. And we know from the California marriage decision now that regardless of what had happened, there was going to have to be a vote on this in California, because the California Supreme Court decided that the Knight Initiative passed back in 2000 was the kind of thing that could not be undone by the legislature. It was going to require a vote of the people. So one way or another, this was going to have to come before the people.
It's better coming before the people with this California Supreme Court on record, I think. We'll hopefully see.
Yeah, no, I agree. I think it's going to be a game changer, one way or the other.
Alexander, did you have any thoughts about the question of whether the poetry matters politically? I mean, you're in the political arena more than the rest of us.
I think it does, and I think that it. I think that the challenge is that the public doesn't necessarily read the opinions, but the extent to which it is made available and used by both politicians and advocates, I think it does make a difference. You know, having read some rather obtuse, the legal opinions that, quite frankly, didn't make any sense to me. I appreciate often when it is something that I can that is understandable. I would say that, the two things, both the Lawrence decision and the California marriage decision to me are extraordinarily important as an African American advocate on LGBT rights because of some of the language that actually lifts up the notion of identity, and that how important that is, and how this single component, the sexuality is integral to identity, but that it is not, and that individuals deserve to be treated equally and fairly in the context of their personal relationships. And so I think that it can be important. Sort of to the earlier question around equal protection, if in fact we could have had a equal protection when that would have worked in the context, and I sort of agree. I hear that would be problematic because of the level of scrutiny that might apply there. I think that we would have, that those arguments from a political point of view would make a difference. The due process when an argument is one that allows a lot of individuals sort of at the social and political level to escape the notion that it has an impact or that they have to respond to it, because this is sort of an individual holding finding. That the notion that you have equal protection of the law is more expansive, and I think that in the political context. And so you can make a more expansive argument that, in fact, we do need to put other laws in place because everywhere discrimination is identified, then if we're going to be, use the legislature to ensure that, in fact, we are protecting people's rights and people's liberty interests, that there is a role for the legislature in doing that.
We have time, I think, for probably one more question.
Sorry. My firm does a little bit of work with GLBT estate planning and POAs and adoptions and such in Nebraska, which is kind of on the opposite end of the spectrum of California. And my question has to do with things like the Federal Interstate Adoption Compact, which sort of says that the incoming state, as adoptive parents move, their laws will govern. And the tradition that domestic relations law is primarily the arena of the states to legislate more than it's the federal legislature. Is it going to be a problem that we develop lots of little pockets of varying laws in these areas as we tend to have a more mobile society and people don't stay in jobs or states for 50 years anymore? And if so, what is the responsible and rational way to fix that, if there is one? Is it turning domestic relations over to a more federally legislated area, or is there another way to reconcile the differences as you move from state to state? Or I realize it's not an easy question to answer in 3 minutes.
Yes.
I'll let the law professors do that.
Well, I think that's going to be a lot of fun. Not for you. Not for anyone who actually has to practice in that area, and not for judges who are confronted with these cases. But I think for academics, we're going to have a field day, and law students. It's going to be an intellectual feast. But the only positive side of that, no, I think it is going. I think one of the things that will do will be to sort of force family law and domestic relations law through a period of fragmentation. The thing that is appealing to me about that as a political project is the kind of denaturalization of the sort of monolithic concept of family. I think it will make it very visible and sort of painfully visible to people who have to deal with the specifics. I do think it will be rather chaotic for a while. And then I think there will have to be, as you suggest, some rationalization of that. I don't think that simply having, same-sex marriage everywhere, for example, which of course I support, is going to be adequate, actually, as a rationalization. So I think it's I think that dynamic in that period is going to be uncomfortable and difficult and in some ways I think kind of tedious. But I think sort of coming out the other side, it really is going to force a re-examination, perhaps along more functional lines, of the kinds of personal relationships that are important in different people's lives and different stages of people's lives. So that's my prediction. I don't know if anybody else wants to.
Well, one way to describe it is chaos. Another way to describe it would be federalism. That is.
Are they different?
No. It's just a better way of describing it. No, I think that's essentially right. But I think the first task the first political task ought to be the one that Paul identified, which is to get rid of the part of DOMA that prevents the federal government from recognizing same-sex marriages in the states. That, to me, is an affront to federalism as well. Right. I hope that the next administration, whoever that is, will take that on.
Okay, well, we're out of time. I want to thank you all for coming and thank our terrific panelists.
So you're going to come play with me on Monday?
Yeah. Great. Unless I have a crisis.
I know.